says that the settlement was not negotiated in good faith because it wasn't negotiated with the other water users in the San Juan River Basin. He is simply changing the standard that the court put for the first prong. The first prong is, was the settlement a product of a good faith negotiation? We have demonstrated it was. We negotiated in good faith and at arm's length with the state of New Mexico and with the United States. We were not required to negotiate with every other water user in this basin because simply we are not negotiating their water rights. And as Mr. Utton pointed out in his opening statement, we went far beyond what was required in the Hickory settlement or in any other settlement of a subfile. We are simply not negotiating here with the other parties. But we reached out to the other parties on numerous occasions to provide them with a draft agreement. We allowed public comment to occur, and we took the comments very seriously. The state has submitted the affidavit of John Whipple, I believe it's attachment 6 or exhibit 6, in that affidavit that spells out what the state received by way of public comment and how they changed the settlement agreement accordingly to respond to public comments. They wanted, and we all wanted, to make a settlement that would work for everybody, to create a win-win situation. Mr. Marshall states that the settlement negotiation was nothing but a sham, and he offers the affidavit of Mr. Rogers to say, in his opinion, the settlement was nothing but a sham. Now, we have submitted affidavits from all three parties, their principal experts, Mr. Benet, Mr. Whipple, and Dr. Leeper. Those affidavits, yes, they do express opinion from time to time, but they lay out factual allegations of what happened in the negotiations, factual allegations that have not been disputed. For example, fact that as a result of the public comments that were received, the settlement included a top water bank. Fact, as a result of the comments that were received, limitations were imposed on the hogback and the Fruitland irrigation projects in terms of their total diversion requirements. Fact, as a result of the objections and comments from the non-settling parties, we included in the settlement an alternate water supply to provide 12,000 acre-feet of storage water from the Navajo Nation's storage contract from Navajo Reservoir to be used before the Navajo Nation could assert a priority call against the upstream non-Indian water users. The affidavit goes on and talks about all of the elements that were included in the settlement in response to concerns by the public, things that we were not required to do, and the Navajo Nation bent over backwards to accommodate the public as much as possible, even though we were not attempting to settle the water rights of any party other than the Navajo Nation. Now, Mr. Horner will tell you that the way the settlement worked...
Let me just back up a second.
Sure.
So the question of dueling affidavits. We have Mr. Rogers' affidavit, and we have the affidavits of the settling parties, Mr. Benet and Mr. Whipper and Mr. Leeper. I'm not in a position at this point to be weighing what's in the affidavits.
And I'm not suggesting to Your Honor that there's a factual dispute here. The difference is that the affidavits that have been offered by the non-settling parties are expressions of opinion. In Mr. Rogers' opinion, he thinks the negotiation was a sham. What is the basis for that? We don't know. Now, we do know from the affidavits of the settling parties what steps were taken to ameliorate the impacts on the non-Indian parties. So the important point here is that these are elements of fact that we have set out and that are really not controverted by the non-settling parties. I'd like to talk for a moment about Mr. Horner's allegations that water was taken from the non-Indian irrigators and given to the Navajo Nation. I want to just state my outrage at the beginning that in this day and age, we would talk about giving anything to people who have had so much taken away from them historically. And nothing here is being given to the Navajo Nation. We are not asking the court to give the Navajo Nation anything. We are here to ask the court to recognize legitimate water rights of the Navajo Nation. Recognize water that has historically been used by the Navajo Nation at their projects on Hogback and Fruitland. Water rights that have been authorized to be used through acts of Congress for both the Navajo Indian Irrigation Project and the Navajo Gallup Project. There's simply nothing is being given to the Navajo Nation and nothing is being taken away from any of the non-Indian irrigators. Mr. Horner says that if the Navajo Nation gets water rights, there has to be an acre-foot for acre-foot reduction, transferring water from the non-Indians to the Navajo Nation. Absolutely false. Absolutely false. The direct flow diverters in the basin are using water from the San Juan River when that water is available. The Navajo Nation is a direct flow diverter at Hogback and Fruitland, but the bulk of the water that the Navajo Nation would have recognized in the settlement is coming out of storage. How does this work? Water goes into storage in priority. In priority. Water cannot be held or withheld from the downstream diverters when they need water because they have the senior water right. Water goes into storage in priority. It is not taken away from downstream water users that have a right that is senior to that of the reservoir. Now, the notion that Mr. Oxford says, which is, well, you simply cannot store water beyond your beneficial use in any given year, that defeats the entire purpose of storage. Storage reservoirs are built throughout the West for the purpose of mitigating the effect of drought. You store water in any year when you've got an abundance of supply so that you can use it during times when the supplies are short. Under the theory that the non-settling parties have, which is that water that's in Navajo Reservoir is available for direct flow diverters once it's released, they have no legal basis for it. It's contrary to law, and it's contrary to common sense, Your Honor. No one would build a reservoir. No one would build a reservoir if, in fact, they couldn't use the water that's stored, because downstream water users who have a senior right to that reservoir have the right to take water once it's released. The water is put into that reservoir in priority. Once it's in that reservoir, it is not available for direct flow diverters. And in this instance, we even have an act of Congress passed in 1962 that says direct flow diverters cannot take water that was stored in Navajo Reservoir without a storage contract. It's a matter of federal law, it's a matter of state law, and most importantly, it's a matter of common sense. The idea that direct flow diverters can take away a storage right just makes absolutely no sense. Now, Mr. Oxford argues that the 12,000 acre-feet of alternate water supply is of no value to them because they cannot get Navajo Reservoir contracts. Again, that's a misstatement of how the settlement works. The way the settlement works is that the Navajo Nation is agreeing that before it exercises a priority call for its senior water rights for the Hogback and Fruitland projects, before it exercises that call, it will release 12,000 acre-feet of its storage right for use. Whether the Navajo Nation uses that water or whether the direct flow diverters use that water, it makes no difference. It reduces the likelihood of a call against the upstream water users. And Mr. Whipple's affidavit and his analysis show that the risks of call are reduced significantly as a result of the 12,000 acre-feet of release. The Luna irrigation case simply doesn't stand for the proposition that once water is released out of a reservoir, it becomes available for appropriation by any party. The Luna irrigation case simply stands for a rather unremarkable proposition that water released from a reservoir in a water course flowing through the state of New Mexico is subject to administration by the state of New Mexico. That's a rather unremarkable proposition. It doesn't stand for the proposition that the storage owner loses the rights to that water once it's released out of storage so that direct flow diverters can take it. We've heard an awful lot here today about collusion, that somehow that the settling parties have colluded to take water away from everyone else. First of all, I'd like to know where the supporting affidavits are for all these expressions of collusion. Nothing is being taken away from anyone. We are simply quantifying the rights of the Navajo Nation to water in the San Juan River Basin. Those rights are based on historic uses of the Hogback and Fruitland Project, storage rights that we have in Navajo Reservoir by virtue of the 1962 Act, and rights for the Navajo Gallup Project that was authorized in the 2009 legislation.
Mr. Horner makes a point about 100,000 acre feet that have been not used.
Your Honor, I've seen that in his briefs numerous times, and I'm still curious where he gets those numbers from, because it's not supported by any affidavits relative to water not being used. But my guess of what he's talking about here is that the water that's not being used, in his view, is water for the Navajo Indian Irrigation Project that has not been completed. The United States promised an irrigation project of 110,630 acres in size, and that project is roughly 2/3 completed today. So that's water that hasn't been used historically, because the reservoir hasn't been completed. The irrigation project hasn't been completed. The water for the Navajo Gallup project hasn't been historically used because that project has not been built. That's what we call the new water in this settlement, and that's approximately 27,000 acre feet of new water in the settlement. So I'm not clear where he gets those numbers from. They are simply not supported by affidavit. And with that, that's really all I really wanted to emphasize, is that nothing is being taken away. They are of the opinion that the settlement was a product of collusion or bad faith. That's their opinion. They have offered no facts to demonstrate any bad faith. Settling parties have provided more than sufficient factual allegation to support their prima facie case that the settlement was a product of good faith negotiations. John?
Thank you, Mr.